I guess I'm going to do say IHL, although, most of these folks think of LOAC, but that's fine.
Actually, I guess there's a question there. I mean, you kind of covered it already, but Law of War, LOAC, IHL, somewhere it'd probably be a good reference to three terms are basically synonymous. Here we're using. Is this on? Is this on? Can we have folks take their seats?
Oh, yeah, this is on.
Sure sounds like it's on.
I guess we have to have this. Good morning. My name is Dr. Chris Bailey, National Intelligence University. I have the honor of moderating this panel with two distinguished luminaries. I would like to say that I did appreciate the introduction by the good captain. As a retired Army officer, I'm a little bit of a loss not having PowerPoint slides, but I think I could make do with this group. First, we are going to hear from Dr. Stephen Neff, University of Edinburgh. He is going to be talking about international humanitarian law. I mean, generally, when we talk about IHL, you could think about law of war, LOAC, IHL, three terms generally synonymous. And then we're going to go to Mr. Mitt Regan, Georgetown Law School, who's going to be talking to us more about IHRL, in other words, international human rights law, law of peacetime, that kind of thing. We'll talk about some of the overlays between the two. So with that, Dr. Neff?
Yes, thank you. And for a start, I will just say rapidly how pleased and flattered I am to be here today at this august gathering, so I hope I'm able to make a modest contribution to it. I'll be talking today, this morning, about particularly about just war thought and its consequences. There is a conventional view amongst lawyers that, well, the medieval just war is all gone. That's for medieval historians. We have a new kind of just war, and that is self-defense. Self-defense being the one and only unilateral resort to armed force that the UN Charter permits. So that is our new kind of just war. I am going to present an alternate view to that. And I am going to stress that the old just war is, first of all, very different in many important ways from the law of self-defense, and more importantly than that, that the old just war ways of thought are still with us to a remarkably larger extent than most people are aware of. So what I'll first of all talk about is just some general features of just wars. I won't go into the content of it specifically, but just to talk about some general overall features of it and how we still see these in the present day law of war. A first point is that the law of just war thought arose out of considerations of personal ethics. That is, when is it permissible for an ordinary individual to use violence against another individual? And a lot of this came out of early Christian thought. But the notion was that there was no special rule for states or for monarchs. Everybody is bound by natural laws of conduct. And the question question then is, when do those permit an individual to resort to force? And then the just war thought ballooned outward from that. A second thing is that the very essence, the core of just war thought, is that it's a self-help law enforcement exercise. Now, many people recoil at the thought of self-help, and in many ways that has been reduced to the barest minimum in national legal systems. In international law, self-help still plays a very large role. And the idea behind a just law is that it was ultimately a law enforcement operation, but law enforcement operation undertaken by the victim of an injustice against the perpetrator. And another key element of it, and this is perhaps the most important and counterintuitive one, is that the just war was actually offensive in character. And this marks a very striking difference from our present conception of self-defense. Self-defense is in principle purely reactive. That is, the aggressor attacks first, and in the classic formulation, the defender then pushes back and repels the aggressor. But the just war was different. The just war was an authorization to strike the first blow, to take the initiative against the wrongdoer. You could say it's defensive war in an ultimate sense, that is, that it is a battle against wrongdoing, or a battle against evil, and defending against evil, but it's the right to take the initiative and strike the first blow. And there were criteria devised or standards devised as to when that was permissible precisely. And the canonical view was that there were 3 just causes of war, and these were set out classically by the famous Hugo Grotius in his book, The Law of War and Peace, in 1625, by coincidence just 4 centuries ago this year. And there were 3 of these just causes. Number 1 was punishment for prior wrongdoing. And here the principle of proportionality was important. Of course, the punishment must fit the crime. But punishing somebody for past misdeeds that are over and done. A second one was oriented towards the present, and that is to obtain something which is due and being withheld. And this might be territory that's occupied unlawfully, or compensation which is owing and which is being stubbornly withheld, and so forth. A third one, and that's the most important, what I call defensive law. I put this in quotation marks because it's not the term that Grotius actually used. But the key thing about defensive war is that it was preemptive in character. And so it was therefore importantly different from what we now call self-defense. It was by definition taking the initiative and striking the enemy in order to ward off an impending attack. And so that's a particularly important distinction between just war and self-defense. Another important point about just war thought was its asymmetry. That is, that the 2 sides fought according to a different set of rules. The unjust side was held to have no right to use force whatsoever. And so the laws, any rules on conduct of war were simply a question of what constraints there were on the just side in order to defeat the unjust side. And therefore, there was no question of belligerents' rights, for example, on the part of the unjust party. No question of entitlement to prisoner of war status for persons captured. And a fifth one was that, to emphasize, is that just war theory was a man-made law, that is, it was a customary law, as we've just heard about it in the keynote address here, that it was, just war thought was a social construction, and therefore in sharp contrast to self-defense. Self-defense was a matter of natural law. Natural law is something which is eternal and universal and invariant and lasting forever, applicable to all places, all persons, and all times. Just war thought, however, was, as I say, a social construction, a matter of custom between nations which can come and go and evolve and change over time. Another feature of just war thought is a low, or in principle, zero tolerance for neutrality. Because remember, the just war is a war by a victim of injustice against a perpetrator. And therefore, there was no question of being neutral. That was shirking one's responsibility. For third parties, the responsibility was to scrupulously refrain from supporting the unjust party and providing whatever aid you could to the just side. And finally, I'll say a word about the conduct governing war. I mentioned before that it was asymmetrical, but here I'll stress that basically the conduct of war on the part of the just party, that's what we're always talking about here, the sole rule was military necessity. And by military necessity, I mean the question of whether something makes a larger than zero contribution to the successful outcome of the war. If it does, then the operation may go ahead. If it does not, then not. In other words, purely gratuitous damage or injury or killing were not permitted. But any kind of action which furthered the cause of the war militarily was permissible without questions of proportionality. And now, to go back to the present position for a moment, the ideal when the UN Charter was drafted was, as I say, that this whole business of the just war would be superseded, thrown into the dustbin of history, and that we would have only the much narrower natural law concept of self-defense. And a number of legal thinkers at the time of the drafting of the Charter, particularly Hans Kelsen, put forward the proposition that from here on in, there will only be one type of armed conflict: aggression and self-defense. Every time there is armed conflict breaking out, somebody will be an aggressor and somebody will be the self-defender. And it's safe to say that the way the world has worked out over the last 3/4 of a century or so has gone against the Kelsen view. And that that there are strong reasons for thinking that the spirit of the domestic of the old just war is still with us. And it's most conspicuous, I think, particularly in the war on terror. I always like to put quotation marks around that because I think that risks giving away too much. As was emphasized in the keynote talk, there is the question of whether the conflict, the struggle against terrorism is the expression I always use as to whether it is really an armed conflict at all or whether it is a matter of law enforcement, which is very much in question. But since the September 11th, President Bush immediately and explicitly took the position, no, the war on terrorism is not just a metaphor or a figure of speech. It is truly an armed conflict. He insisted that it is a war of good against evil, and as in any war, the goal is to subject the enemy's side to one's will. Okay, that is different from self-defense. Self-defense merely pushes the enemy back and defeats an operation. War, in the true sense, is a campaign to subject the enemy to one's will. And we see that in the struggle against terrorism. Also that it is offensive in character. It enables the United States and other countries to take the initiative, to bring the war to the enemy's side, to strike first as necessary. And you could say that this is either defensive war in the grossest sense or punitive warfare, either one. But it involves not mere self-defense, but but offensive operations. We see, too, the question of asymmetry very much to the fore, a stern denial that the terrorist groups such as Al-Qaeda or the Islamic State have any belligerence rights or any entitlement to prisoner of war status. And certainly we have seen an intolerance of neutrality, again going back to President Bush, that whoever is not actually supporting us in this side we regard as being against us. The insistence that that in a struggle between good and evil there can be no middle ground. And finally, let me say a final word just to wind up on the question of the conduct of the conflict. And to a large extent, of course, the United States insists that it is still fighting according to the laws of war. But there have been some instances in which there has been a willingness to step outside of the normal laws of war in the interest of, broadly speaking, military necessity. There was the famous quotation by President Bush that, the Geneva Conventions are a kind of quaint and old-fashioned kind of war. They shouldn't constrain us. What should constrain us is only the necessities of the particular situation as we face it at the time. And I should just perhaps mention here that this willingness to step outside the laws of war has been primarily something by the intelligence community. And military lawyers have by and large struggled against that, so we must give credit where credit is due. But time has run out for now, so we can expand on any of these in the question and answer period. So for now, I can turn over to Mr. Regan.
Thank you very much, Dr. Neff, for that really masterful overview of the evolution of IHL. I'm going to talk about something that not everyone thinks about when they think about armed conflict, which is human rights law. I'm going to discuss the evolution of the relationship between IHL, or law of armed conflict, and human rights law, and then discuss in particular the U.S. position on this relationship. The 2024 U.S. Operational Law Handbook succinctly describes two approaches to thinking about the relationship between these two bodies of law. One is what's known as the displacement view, which is basically that human rights law was designed for and applies during peacetime, but once armed conflict or war begins, it ceases to have any application. And the ostensibly more specialized body of law, IHL, then applies to the conduct within an armed conflict. So this sort of conjures up the notion of a compartmentalization, of a neat division of labor between the two bodies of law, each of which has its own jurisdictional sphere. What the Operational Law Handbook describes as the complementary view is, as the handbook says, an expanding group which includes states and human rights courts view the operation of the application as complementary and overlapping, which is to say human rights law applies at all times. It does not cease to apply when armed conflict occurs, but the two bodies of law need to be harmonized according to the exigencies of the situation. And I think it's fair to say that the view that the two are complementary has gained increasing acceptance in the international community. And its underpinning basically is the notion that human rights law provides a statement of basic human protections, which has to apply at all times, but how those rights are protected may differ in the course of armed conflict. So one way to think about this is the evolution of human rights law from a matter of national to international law. Broadly speaking, what we think of as human rights law began with a focus on how a state treats its own citizens. Right? This is an internal matter governed by, in particular, constitutional law as well as other sources of law. And any attempt on the international level to regulate that was seen as an intrusion on state sovereignty. The 1948 Universal Declaration of Human Rights, however, recognized human rights as an international concern. The Declaration proclaimed the inherent dignity and equal and inalienable rights of all members of the human family. It served as the basis for adoption of basic international protections against the abuse of state power in a variety of different conventions, most notably the International Convention on Civil and Political Rights, or the ICCPR, which is the most extensive statement of what we might think of as negative rights. The vast majority of states in the world have ratified the ICCPR, which means that they have an obligation to ensure that their domestic law conforms to the terms of that convention. So what this means now is that international law includes both IHL and international human rights law. The displacement view reflects recognition that the paradigm cases of the two bodies of law do differ. Human rights law generally assumes a backdrop of enough state exercise of control that the state's able to deal with threats of violence through its policing and its criminal justice system. And the basic concern is that a state do this while respecting the rights of its citizens. By contrast, IHL deals obviously with conditions of violent conflict over which states exercise minimal control. The basic concern is that both sides take steps to minimize unnecessary suffering as much as possible. In this sense, as my colleague David Lubon has put it, IHL focuses on damage control rather than human rights as such. But the complementary view gained currency, in particular at the 1968 UN Tehran International Conference on Human Rights, where the UN General Assembly adopted a resolution saying that fundamental human rights, as reflected in international law and laid down in international instruments, conventions, continue to apply fully in situations of armed conflict. And the UN Secretary General report in 1970 said the international instruments on human rights adopted under the auspices of the United Nations afford a measure of protection certain important rights of all persons involved in armed conflicts, which complements and strengthens the protection derived from the rules of the Geneva Conventions. So, as one commentator puts it, the increasingly influential view is that human rights, by their nature, protect persons at all times and therefore are relevant to and apply in situations of armed conflict. What exactly does that mean, however? Right? It's a little more complicated than that just sort of straightforward categorical statement. And that's because their provisions on the use of force, for instance, are quite different. Right? Human rights law prohibits arbitrary deprivation of life, and in particular, lethal force is limited to situations to prevent, generally speaking, an imminent threat to life or of grave bodily injury. So in other words, a person is liable to attack based on his or her own conduct. Under IHL, by contrast, a combatant may be attacked at any time, regardless of what he or she is doing, whether they're reading, eating, sleeping. They may be attacked based on their status as a combatant, not on their conduct. Civilians can be attacked based on conduct if they're directly participating in hostilities, but only during the period they're doing that. So there is a limited sort of scope for that. In addition, the principle of necessity under human rights law requires that use of force, particularly lethal force, be a last resort. With respect to lethal force, the principle is that one may take life only to save a life. the principle of necessity under IHL is that an attack is lawful if it's expected to provide a concrete and direct military advantage. Right? The principle of proportionality is quite different. Under human rights law, that requires that the level of force that's used be no more than necessary to stop a threat. In other words, the gravity of the threat determines the type of force that can be used. The principle of proportionality under IHL, as many of you may know, requires that expected civilian harm not be excessive compared to anticipated military advantage from an attack. So the question naturally is, well, how can such dramatically different sets of rules apply at the same time? Well, human rights courts have addressed this, and one response is that they have held that, yes, as a conceptual matter, human rights law does not cease to apply during armed conflict, that states have certain human rights obligations outside their borders only in certain circumstances. Generally, these are when they exercise control over territory, control over persons, or are carrying out public functions such as providing security for the local population. This reflects the view that both bodies of law share a common ideal, which is protection of persons from abuse by those who have power over them. A state that exercises control over territory is in a position of power over people who are located within that territory. A state that exercises control over a person, such as having them in custody, has power over that person. A state whose forces encounter individuals when conducting, say, security patrols, carrying out public functions, has power over persons in that they may take them into custody, they may detain them, and are in a position to decide whether or not to use force against them. Right? In each case, the rights that a state is in a position to honor or violate are those that it has an obligation under human rights law to respect. Now, human rights obligations are flexible. With different degrees of control, the state has different obligations. The obligation to protect persons from harm, from third parties, for instance, requires a much greater degree of control over the environment than the duty to respect the prohibition on ill treatment or torture. By contrast, occupation under IHL involves a degree of control that imposes quite expansive obligations on the state, including what we might think of as affirmative obligations of protection and welfare, education, tax collection, medical care, and the like. While most situations of occupation will also entail effective control over the territory, there are situations that are extremely volatile where that's not the case. So let me give you an example. One major case from the European Court of Human Rights involved British troops in 2 provinces in Iraq who were carrying out security functions in an environment that was described as on the verge of anarchy. They did not exercise any effective control over the territory, but they did have the responsibility, in essence, to stand in the shoes of the government that had been displaced to provide security for the local population. So the court found that the UK did not have enough control over the territory to ensure all convention rights. It had at least control over its own use of force when its soldiers on patrol killed 5 civilians, even though it didn't have them in custody. Right? So to some degree, human rights courts have articulated standards that describe situations in which the applicability of human rights law simultaneously with armed conflict does in fact arise, right? And the International Court of Justice has said in those situations there are 3 possibilities. One is that some rights are explicitly governed by IHL, right, in situations that involve combat on the battlefield, when lethal force may be used against whom. Military necessity, the IHL principle of distinction between combatants and innocent civilians, the IHL principle of proportionality that I described a minute ago, the IHL principle of precautions, who may be detained, combatants and civilians who pose a security risk. And so, as another case of the International Court of Justice said, the test of what is an arbitrary deprivation of life, excuse me, in these situations is determined by armed conflict, right? As the court said, whether a particular loss of life through the use of a certain weapon in warfare is to be considered an arbitrary deprivation of life under human rights law can only be decided by reference to the law applicable in armed conflict, not deduced from the terms of the human rights instrument. So in some cases, IHL basically may control a field to the extent that it explicitly regulates conduct in question. Second, some conduct, some situations may be governed exclusively by human rights law. The prohibition on torture and cruel, inhuman, and degrading treatment are terms that are drawn from human rights law. They apply during armed conflict. So we can look to that body of law to determine exactly what they mean. And then finally, there may be situations where IHL does not explicitly regulate, right? And the goal there is to try to harmonize the two bodies of law as much as possible. So for instance, Common Article 3, which applies during a non-international armed conflict, says the passing of sentences, carrying out of executions, without a judgment pronounced by a court affording all the judicial guarantees which are recognized as indispensable by civilized people. So that's a requirement, but what precisely those guarantees are is not spelled out in Common Article 3 or anywhere else in the Geneva Conventions. So you can look to human rights law on due process and draw on some of that body of law, at the same time recognizing that you're not in a peacetime situation. You're going to have to adapt the procedures to the exigencies of the fact that you're in armed conflict, right? But at least human rights law can provide some broad guidance. A very good example is a European Court of Human Rights case called Hassan versus the UK, where a young man was detained during the conflict in Iraq by UK forces as a possible combatant, or at least as a civilian who posed a security risk. He was detained on April 23, interviewed twice to see if he should continue to be detained, and released on May 4. On September 1, he was found dead with 8 bullet wounds from an AK-47 in his chest. The detainee's brother brought a claim that UK forces violated the European Convention on Human Rights by failing to carry out an investigation into circumstances of his detention, his treatment, and his death. Now, human rights law says deprivation of liberty must be lawful, right? And the court said that means, in this case, the detention must comply with the rules of IHL, insofar as those rules are in keeping with the fundamental purpose of the human rights law protection of liberty, which is to protect the individual from arbitrariness, right? And then the European Convention says people have to be, if they're detained, have to be informed promptly of the reasons they're arrested. They have to be brought before some sort of official within a reasonable time or released pending trial. There have to be proceedings by which the lawfulness of the detention can be decided quickly. And the court said these are protections under human rights law, but they have to be applied in a way that takes into account the context of armed conflict. And the court said basically in this case, the UK forces had reason to believe the deceased might be either a prisoner of war or a civilian who posed a security risk. So there was a valid reason for, a reasonable reason for the detention. Almost immediately, he was screened with 2 interviews to determine whether, in fact, he did pose a risk or was a combatant. based on the questions he was asked, the reason he was being detained would have been evident. Therefore, his capture and detention was consistent with the European Convention on Human Rights. It was not arbitrary, right? Now, these sorts of procedures during peacetime might well not be sufficient because the state exercises much more control, right? So in very broad terms, the closer to the battlefield and the conduct of hostilities, IHL has more weight because its rules are oriented to that, and some of them actually speak specifically and directly cover behavior. Where the situation is more remote from the battlefield and state authorities have enough control to be able to carry out law enforcement operations, human rights law is given more weight. Now, finally, I'm just going to close by saying the U.S. Interprets the ICCPR as not applying outside the U.S., in contrast to the UN Human Rights Committee interpretation of the convention. But there are certain human rights provisions that are customary international law, known as jus cogens, compelling law, right? And the 2024 U.S. Operational Law Handbook says, jus cogens consist of peremptory norms so fundamental and universally accepted that they may never be derogated from. Prohibition on genocide, slavery, murder, forced disappearance, torture, and so forth are jus cogens. They apply even though they may not be necessarily, they don't need to be expressly memorialized in a particular instrument, although some of them are. So the State Department has said that a time of war does not suspend the operation of human rights law to matters within its scope, right? And says that IHRL and IHL are in many respects complementary and mutually reinforcing. The Department of Defense Law of War Manual says that apparent conflicts between human rights treaties and IHL can be resolved by the principle that the law of war is the specialized body of law during situations of armed conflict and is controlling with respect to the conduct of hostilities, right? But a human rights law treaty would be controlling with respect to matters that are not specifically addressed by IHL. And it's important to realize that IHL is not completely exhaustive. It does set forth some basic rules with respect to the use of force, but there are provisions that have to be interpreted. There are some gaps, so it's not all-encompassing. And the Operational Law Manual says the U.S. will consider rule by rule whether IHL displaces applicable provisions of human rights law, or whether human rights law applies because IHL is silent or its guidance is inadequate, right? So the U.S. also does accept the notion that human rights law can apply in certain circumstances in armed conflict, right? Even though it takes a particular position with respect to the extraterritorial application of a particular convention. Again, jus cogens sorts of customary international law, human rights norms are recognized. So that's the way in which, this very simple statement that the two bodies of law exist and apply simultaneously, that's the way actually you sort of have to work it through, right? And the Operational Law Manual, I think, does a really excellent job of advising Judge Advocate Generals on how to go through that sort of analysis. So I will end there.
Gentlemen, thank you for that very interesting exposition. This topic of displacement from IHRL to IHL, I think, is very interesting. And we've received really two views here. One is that there's a complete displacement, the lex specialis, and also this view on complementarity, which I tend to subscribe to. My argument is that there is no intellectual apartheid between these two bodies of law as it applies to conflict. My question for you is, how do you see the early U.S. decision to switch from a human rights view on GWAT to a law of war? I mean, what were the advantages, disadvantages of that early decision?
Well, I think the U.S., I mean, I don't speak with any inside information. I think the U.S. felt that it was dealing with a transnational organization for which conventional law enforcement measures would be inadequate to address the threat that that organization posed, and that the use of military force might well be necessary. I think the U.S. also, as the first speaker mentioned, did take the position that members of non-state armed groups could be considered combatants, although the IHL doesn't really speak to the status of members of organized armed groups. And the ICRC also has taken the position that they can be combatants if they carry out certain functions continuously. So I think, I mean, the sense, as I understand it, was that this provided more latitude, that strictly applying human rights law might be too restrictive in the sense that it's, again, as I said, it's a conduct-based test for use of lethal force. So someone would have to be posing an imminent threat to life. At the same time, I think it's important to recognize that in 2013, with respect to direct action outside of areas of active hostilities, President Obama adopted a framework that applied what is very similar to human rights law. And this applied most relevantly to drone strikes, right, in the federally administered tribal areas, in particular in Pakistan, right, which said that there has to be, capture has to be infeasible, which is basically a human rights standard. Use of force has to be a last resort. Said that there need to be near certainty of no civilian casualties, right? And then near certainty of the location of the identification of the person. I think that was a response to some international reaction that perhaps the armed conflict paradigm was a bit too expansive, right? And I had a very interesting discussion in my class on Wednesday about, well, is the U.S. still in an armed conflict with al-Qaeda? I mean, the U.S. takes a position that it is, right? If so, it certainly doesn't resemble anything like World War II or the Korean War. But then some say, well, that's the nature of conflicts with non-state armed groups, right? So I think, I think that the U.S. felt that it gained some advantages, some freedom of action. I think there was some international reaction. I think, maybe they're sort of calibrating that now. Okay. Stephen, I wonder what your thoughts.
I think that's fine.
Okay.
Thank you. Do we have questions from the audience? Go ahead. And then